Hello, everyone, and welcome to Ankara's Trust Week presentation, where our panel of experts will share their perspective on the California AG's example of CCPA noncompliance. Introducing our panel today, we have Dave Manek, who leads Ankara's data privacy practice. His team of data privacy, information security, and data management experts have a passion for helping corporations and outside counsel implement complex data privacy compliance solutions. Dave is leading Ankara's solution to assist organizations demonstrate compliance with GDPR, CCPA, and other emerging privacy regulations such as CPRA. He is currently serving as a data protection officer for his clients and holds many professional certifications, including the CIPP/E and CIPM. Alan Friel is a co-chair of Squire Patton Boggs Global Data Privacy, Cybersecurity, and Data Asset Practice, and is an adjunct professor at the Loyola School of Law. His team has worked with hundreds of clients in developing and operating CCPA compliance programs and is helping clients respond to the evolving CCPA enforcement positions and prepare for the changes that CPRA and new Virginia and Colorado privacy laws will bring by 2023. And finally, Colleen Yushchak is a managing director in the Washington, D.C. office of Ankara. Colleen has 20+ years of experience in technology and litigation consulting, including compliance consulting related to the EU and US privacy and data protection laws, cybersecurity and privacy risk assessment, cyber breach and incident response, e-discovery and large claims litigations, change management and information governance. Colleen has developed privacy programs for dozens of clients across various industries, spanning from retail to medical device manufacturers. Colleen supported one of the largest multinational advertising and public relations companies in the world with their GDPR compliance efforts, including development of a data inventory, data protection impact assessment, DPIAS, and policies and procedures to support GDPR compliance. And with that, I'd like to pass this over to Dave Manek to start this presentation.
Thanks, Paul. Appreciate the intro, and thanks everyone for spending the next 40 minutes or so with us. I wanted to give a quick shout out to the OneTrust team. They've been a great partner of ours over the last few years. We've helped joint clients implement over 75 large implementations of OneTrust at this point. We usually use OneTrust as part of larger data privacy modernization efforts. Some clients will leverage us as a managed service. Some clients will leverage us to help with large-scale implementation and strategy. We also will do just discrete implementation of OneTrust modules, like help build a data inventory using OneTrust. We're doing a lot of work around cookies these days, as we'll get into the presentation here. You'll see that cookies and the consumer response process are two of the highest enforced areas of CCPA. So just wanted to say thanks to OneTrust for letting us present today, and we look forward to continued partnership with y'all. So we have a really great presentation queued up for you. What we're going to focus on are the 27 areas of noncompliance or examples of noncompliance that the California AG published a few months ago. We'll summarize some key metrics and also go into discrete examples of the narratives of noncompliance, talk about the specific example, talk about practical solutions, and then how the OneTrust tool can be used to help from a proactive perspective and also from a reactive perspective with scenarios going on within the cure period. We'll then summarize that as part of a checklist, and we'll talk a little bit about planning for 2023 as CPRA goes live in Virginia and Colorado. So a quick summary of what's going on. So we know that back in July of 2020, or starting in July of 2020, so more than a year ago, the California AG started sending notifications of alleged noncompliance to companies. And within those notifications, which were really letters, organizations had a 30-day window to cure that noncompliance. And then roughly a year later, back in June of 2021, the OAG released 27 illustrative examples of the alleged noncompliance, and that's going to be the focus for today. We know that, we believe that all of the organizations that have received these letters of noncompliance have taken steps to cure them. within the 30-day window. We're not aware of OAG issuing penalties as of yet, but I think all of us on this webinar are students of privacy and know that come January 1, 2023, under CPRA, that cure period will no longer be available to us. At the bottom of the slide here, you'll see a link to the Security Privacy Bites post that Alan's team did, which is a really nice summary of the CCPA enforcement and also the compliance tool that was launched. That last bullet there is a link to a tool that the AG published where consumers can actually go and submit a complaint. And that tool will generate a demand for care, and we believe start the 30-day clock. So if you haven't seen that tool, I think it's also something that we all need to check out.
Yeah, and then Dave, I think it's worth noting that that's sort of an aggressive position that a consumer can start the cure clock for the AG in that manner. And the other thing I've noticed in recent demand letters from the AG is they're now starting to take the position that if you knew of the violation, the clock starts upon your knowledge of the violation. It doesn't require the AG to let you know that they know.
That's very interesting, and I think important, and let's say applicable to a lot of what we're dealing with on a day-to-day basis.
Okay, so on this next slide here, we're going to talk about some initial observations of the California AG's examples of non-compliance that were provided. First, the 27 examples of non-compliance included examples from the industries that you see on this slide. So any industry on this slide that had multiple examples has a number next to it. And so probably not surprising, companies in the business of buying and selling personal data, or who share personal data or permit others to collect personal data in connection with interest-based advertising, were pretty prevalent throughout all of the examples. So you'll see data broker, social media, online event sales, online advertising, online marketing. So that's not too surprising. But in addition, companies that collect and process sensitive data also were pretty prevalent throughout the examples. So companies that deal with minors data or geolocation data. So you see the video gaming, children's toy distributor, children's event, geolocation data broker, education technology. So I don't think that's too surprising. I mean, there's a high risk associated with some of those processing activities, and definitely some more stringent requirements for minors data. And then lastly, perhaps just to highlight that pretty much any company that processes personal data is going to still have to comply with the CCPA. You can see there's other industry examples in there like automotive, consumer electronics, grocery stores, clothing retailers, and pet industries. So definitely the full gamut of industries. Back to you, Dave.
So on this slide, what we're showing is a summary of the discrete areas of noncompliance within the 27 narratives of noncompliance. So the way we created this was we just read through all 27 narratives of noncompliance that the AG published, and within each narrative of noncompliance, there were usually more than one discrete issue that was identified. So within the 27 examples of noncompliance, we basically tagged 64 discrete issues. And you'll see here at the top of the frequency chart, the first major category is that organizations were missing methods to submit requests or missing proper instructions related to consumer rights. That has occurred 23% of the time. And then as we look down, the second most common area of noncompliance is the organizations were missing references to their sale position, or they were missing reference to having no knowledge of a sale in the prior 12 months for minors. Similarly, if we go to number 3, the organizations were missing do not sell my personal information linked or opt-out process for do not sell. And I know Alan will probably jump in here and correct me, but it's important to note that, you know, we have 27 examples that we can read about. You know, the team presenting to you has helped organizations through California AG investigations, but we know there's been hundreds of letters sent. So this is really just a small sample of the population of letters that was sent. And you'll see that the first one, consumer rights being a big topic, and then also items 2 and 3 there really both relate to the sale of data. So if you add 2 and 3 together, we're seeing that occur 28% of the time. As you work your way through the list, missing pre-collection notices, missing instructions regarding the right to not be discriminated against, missing service provider clauses and contracts, that's a key operational issue, missing instructions for authorized agents, that's line 11. And there's others in here that we're going to tackle as part of our walkthrough of specific examples. So we're going to transition now and start to actually dig into, we have 5 specific examples queued up to talk through with the time we have. And then there's additional 5 in the appendix. So I assume these slides will be published on our portal for you all to access in Trust Week. So 5 now, and then there's 5 in the appendix. And the first one here, Alan, I'll turn over to you.
Sure. So there's a couple things to talk about here. But to set the stage, you know, it has not been without controversy as to whether or not third-party cookies are a sale by the publisher. And in fact, the digital advertising industry started to develop 2 different self-regulatory compliance programs, one by the DAA, Digital Advertising Association, the folks that brought us the opt-out of interest-based advertising. They worked off of that existing opt-out system to create an opt-out of sale, but taking the position that it is the ad tech company that is the business or third party that is doing the collection on the publisher's site. The publisher passes through to the user the notice of opt-out. The AG has rejected that, believing that although may be potentially effective for the ad tech companies' downstream sales, that the publisher has the obligation in the first instance to stop the collection, where it's not limited for service provider processing, which under the statute, what a service provider can do in restricted data processing, very limited other than what's necessary to achieve the business purpose of the client in the service process. They get there by looking at the words making available in the definition of sale. So in other words, by allowing the cookie to be associated with your site, you're making the personal information available. The contrary argument is no, I'm making the users available if there's still an independent collection. Well, that has not, it is subject to challenge, and it is being challenged by at least one company that I know of. And we'll have to see what the courts agree with. But as of right now, the enforcement position is unless the data is restricted to what is permitted of a service provider, it is a sale, and the opt-out must be called do not sell. And the AG had picked out of the 27 examples, 3 on this issue. And continues to send out letters on this, including one that one of my clients got last week. So they've not stopped on this. And in fact, we understand that what they're doing is working their way down the list of the most trafficked websites that are there, running a cookie scan, which anyone can do with a browser plugin. And if there are interest-based advertising cookies and there's not a do not sell option that turns those cookies off, sending a letter. The other, so I guess the point is for all the publishers that sort of kicked the can down the road last year, waiting to see if there was any guidance, and then got confidence in there not being guidance in the regs. There's now guidance in these published enforcement decisions or summaries, and the ongoing enforcement activity of the AG. So now's the time to revisit your cookie banners, your cookie consent management platforms, and how you describe cookies and do not sell in your notice. The other thing is global privacy controls. The regs created this concept of having to look for and honor clear manifestations of assent to opt out through things like browser signals. And there is an open source global privacy control that has been adopted by some browsers. It is still not entirely clear that it meets the standard of clear manifestation of assent. But the AG has suggested that it does, both in tweets and in enforcement actions. Not every letter that has a claim based on cookies has a claim based on GPC, and it's unclear if the AG is really going to fight this, in part because the whole concept of GPC changes next year with CCPRA anyway, where the clear reading of the statute makes it optional, not mandatory. So it does seem to be questionable enforcement discretion to be enforcing something that appears to be headed towards being optional within the next 15 months anyway. Next slide, please. Another area of enforcement has been financial incentive programs. And this is another one where companies need to go back and revisit their compliance position, because what is a financial incentive changed significantly throughout the rulemaking process. And so now the definition of a financial incentive is something of value that's provided in connection with the collection of personal information as opposed to in consideration for. So it's not a one-for-one bargain for exchange. It's just basically anytime there's personal information being collected and there's a financial incentive associated with it. And the AG, at least one action that I'm aware of, takes the position that it is with respect to any program participant, not all program participants. So what if there is a financial incentive, what do you need to do? It needs to be on an opt-in basis. There needs to be the ability to withdraw consent. There needs to be a lot of very relatively complex disclosures prior to subscription to the plan and the collection of the data, including descriptions of the valuation of the data, and that there is a reasonable exchange between the benefit and the value of the data. The regs include a bunch of different methodologies for it. If a company does not publish things like the cost of the program or the value of the benefits given, then it should be able to rely on the trade secret provisions of the CCPA to not, in other words, publish the methodology description, but not the actual math or the result of completing the methodology. Although be prepared to show that if inquired by the AG. Next slide, turning it back over to Ankura.
Thanks, Ellen. I thought those were great examples. Okay, so moving on to the next slide, which is an example around the topic of the sale of minors data, which I hinted on one of the earlier slides is definitely an area where there's some sensitivity. So under the CCPA, a business that's has not received consent to sell the personal information of a minor is prohibited from selling that information unless the business has authorization from either the minor or their parent or legal guardian. So on this slide, in this example, an online gaming company installed third-party advertising software on their mobile app. And the mobile app actually shared personal information of its players, including minors that were aged 13 to 15, with that third party. On top of that, the gaming company didn't have an opt-out mechanism for adults or an opt-in mechanism for minors. So there was no choice there on the sale of that data. So on the right-hand side of the slide, we kind of review some of our recommended solutions to avoid issues like this. And really the first one being just making sure your data inventory is up to date and that it identifies any instances of a sale of minors' data. So in the CCPA, that would be anyone under the age of 16. So the data inventory should also identify for you any instances of sharing of that minor's data in case it's determined to be a sale under the CCPA. And I would recommend not leaving that analysis or that decision about whether it's a sale to, a respondent in the data inventory or an asset owner. It really is a legal determination that should be worked with outside counsel and in-house, the inside team. For any identified sales of minors' data, so if you do find that you're selling data, make sure that you either stop selling that data or make sure that you're tracking affirmative opt-in consent from either the minor or, consumer, the parent or guardian consent as well would also work for anyone under the age of 13. And then if you identify that you collect minors' personal information, you can add some additional privacy protections, including age gating or parental verification procedures, right, to your consumer process. So there's going to need to be some additional safeguards that you put in place, as well as additional security controls. We work with our clients all the time to let them know where they are processing minors' data and make sure that that's alerted to the information security team and that the proper controls are put in place and access controls are in place, that sort of thing. And then lastly, don't forget apps. So if you have a mobile app, make sure you understand what third-party sharing is happening associated with that app and make sure that you address that, appropriately. And the lower right here, we talk about a few of the OneTrust modules that we use a lot to kind of execute on some of these solutions, including the data mapping and assessment automation to make sure the data inventory is up to date, consent management module, and the mobile app for consent as well. So some great tools that OneTrust offers there. But unfortunately, the CCPA requirements around minors' data and the different consent requirements don't always match up to requirements under other regulations like COPPA or the GDPR or even China's new regulation. So even within Europe, the age of consent is going to vary by country. So it's complicated. The GDPR sets a general age of consent at 16. Which means you can't legally process the data of a data subject 15 years old and younger unless you have permission from their parents. In China, it's 14. So it can get a little complicated and operationalizing it can be tough. So that's where we use the OneTrust module for the data inventory to add a question where we identify when minors' data is being processed, but we also figure out the age. So we can, include in the question different choices to say, okay, are you processing minors' data? If so, is it age 14 to 16? Is it age 12 to 13? What are the ages? And then you can kind of address based on which regulations are in play. So Alan, we talked a little bit about this earlier, specifically the interplay between the CCPA and COPPA and how those apply in the US. Did you have anything you wanted to add here on that?
Yeah, I guess you mentioned age gates. That's where we see people sort of make the most inadvertent error. Put an age gate in, and by doing it, they either engage in impermissible coaching. You've got to be 13 to use this service. How old are you, right? Don't do that. The FTC will definitely go after you, and they have very heavy civil penalty authority under COPPA. The other is you catch someone in your neutral gate, and you don't. Now you have knowledge that they're under the age of 13, and you don't prevent the collection of data. So you need to drop a session cookie to prevent re-registration and disable the back button, for instance. If you are going to seek parental verification, there are very complex requirements with respect to the methodology, the notice for what qualifies as VPC under COPPA. So to be aware of that. The FTC has really good FAQs on this with a lot of examples.
Thanks, Alan. Okay, so we're moving on to the next example here. And this one's really around keeping your privacy notices current, making sure they have all the key components. You guys are seeing this as a recurring theme. I mean, it's the place where the California AG can see right away if you're not compliant. And this slide's also going to kind of tie in again why a data inventory is so important to helping you to make sure your privacy notice is current. So in this example, an organization was missing a compliant CCPA notice. They did not describe the consumer rights that consumers had under the CCPA, nor did the notice provide details about what personal information they were collecting, how it was being used, and how it was being sold, or if it was being sold. They also didn't have a sufficient mechanism for a consumer to submit a request at all from a consumer rights perspective, and they did not have a do not sell button. So they were kind of violating a lot of the basics of a privacy notice under the CCPA. So on the right-hand side here, we're talking again about a few different ways that you can address this, data inventory being a key support for this. If the inventory is constructed properly, we can use that to take the output from the inventory and update the privacy notice so we know it's accurate. You know, if you're not using a data inventory, it's really hard to have a reasonable assurance as to what you are doing with data. So the goal of the inventory is really to understand what data are you collecting, what are you doing with it, why are you collecting it, how are you using it, how are you protecting it, and who are you sharing it with. So, and then you can take the results of that data inventory and just flow it through to your pre-collection notice. So it's really kind of a narrative, like the pre-collection notice is kind of a narrative summary of your data inventory, which is the much more detailed piece of the puzzle. The next thing that you should do is make sure you implement a do not sell link. Or if you take the position that you do not sell, you know, there's different aspects and different ways to address that. And you just have to be clear. I know Alan has a lot of clients too that probably he's been working with on this. And if there's confusion about whether or not there's a sale, that's when you're going to get in trouble. So make sure you're running a cookie scan, because we talked about cookies earlier. Make sure you're looking at the third-party cookies and you're identifying those vendors and making sure you have a technical control in place to limit processing. And in particular, if you have a service provider, make sure you have a contract that, you know, is CCPA compliant, because that is absolutely something the California AG is looking into. And then lastly, just make sure you have a great consumer response process. You know, it has to be well thought out. It has to work. You can use the final regulations as a guidepost. You should have people testing it and making sure it works. If you haven't had a certain kind of request, you should be running through scenarios where you're prepared for that. It really is not easy all the time. And for example, with a lot of our clients, when they get a do not sell, a access request or a right to delete, they're having to reach out to 30, 40, or 50 different owners within the company to make sure that they can act on those requests. So if they haven't seen it until it's go time, it's going to be pretty hard to respond in the proper way. Back to you, Dave. Oh, and actually, before I do that, there's some OneTrust modules on here that you can use to help with the data inventory with consent, and of course the privacy rights module, the DSAR module in OneTrust, which is probably one of the most customizable versions of a consumer request process that we've been able to use.
Very good. And maybe building on the consumer response process, this next topic related to a social media organization that was not responding timely to CCPA rights requests. And so there was just an inherent backlog of requests that were building. The AG, one of the consumers submitted a complaint to the AG, which then triggered this scenario. And I think OneTrust has a nice solution to help with that, which is their targeted data discovery. And we've been helping organizations implement that tool, which is kind of a second stage of the privacy rights module. So the privacy rights module is the module that's utilized to, for example, put a form up on the website. So you go to the privacy notice, click the link, then a form pops up, and the user can select the type of request that that they're submitting, along with other information that could be utilized in the verification process. The targeted data discovery is an extension of that, where we're helping our clients basically use API functionality in OneTrust to connect to the underlying systems within the client's environment and help extract data or effectuate erasure requests, for example. And this is a nice solution, I think, for organizations that have a backlog building for two reasons. One, you can build the business case to invest in this solution because you can actually kind of quantify the effort spent to manually respond versus the cost to invest in targeted data discovery. And what we've seen is even when we're using targeted data discovery, the privacy office still has really good control over the response process. You're still interacting with the data subject, for example, prior to initiating the semi-automated functionality that exists within targeted data discovery. One key piece that we've learned through our implementation of this module is that OneTrust is great connecting to different systems through the native API functionality built within OneTrust. Clients, and as part of our projects, one of the first things we need to do is due diligence on the client side systems to make sure that they have, those client side systems also have API functionality to connect to OneTrust. Because it's a two-way scenario in that OneTrust has great API connection functionality, but some systems on the client side are really old and they may not have that same functionality. And so we may have to build that or think about a different way to different system to actually connect into OneTrust. So just a tip there for those who are thinking about going through the process of implementing targeted data discovery. So there's 5 other examples in the appendix, but we have limited time with you all. We're going to move on. Here we have a checklist of CCPA enforcement topics to consider as part of year end. The first one there related to consumer rights. We've spent the last few minutes talking about that, but you know, Alan uses the term rulemaking process, and what he's referring to there is the regs that have come out. So, you know, if you're not following this, if you weren't following this super close, right, the CCPA law is published, and then there were a series of regs that were refined over time. And the regs have very specific instructions on what needs to go in privacy notices, how consumer response processes need to be configured. The regs actually, I think, are great because they take a lot of the ambiguity that was in the law out and give us some clear direction. If you're not a student of the regs, you're likely missing part of the puzzle. And so, for example, if you study the regs, you'll see references in there that as part of the consumer rights process, we need to include instructions that the consumer won't be discriminated against, and also include instructions for authorized agents to submit requests on behalf of consumers. Those 2 areas are the most frequently left out of privacy notices we've seen as we've studied notices over time and helped our clients.
Dave, I have one quick note there too. I noticed in one of the announcements that they plan to double the current regs before everything goes into effect. So I know that they're going to basically add more to the team, you know, the enforcement team, and they're going to double the written regulations. So everyone should really start spending some time getting familiar with the regs that are already out there because they're going to double in the next year.
Yeah, well, that's for CPRA, right? That's what
Yep.
geared into. Yeah. The second item there, both Colleen and Alan have talked about this, but you know, revisiting the sale position. If you take the position that you do not sell, do an analysis of the third-party cookies on the website. See if you can tie the vendors associated with those third-party cookies up as a service provider via a contract, or review what they have on their website, or see if there's a technical control in place. But the sale issue is, you know, as we've demonstrated, one of the highest enforced actions, and is causing a lot of activity on the enforcement and compliance side. Alan, do you want to comment on the sale position? And then I also know you wanted to comment on the next 2 bullets.
Yeah, so sort of 2 things that I think are worth noting, because when it gets to the digital world, it gets really complex. So the first is if you're selling only because you've got third-party cookies, then that needs to be explained, and the consumer rights request portal which is collecting their name and their email address, that's not going to do anything, right? If you, let's say you're also selling emails, you've got a do not sell there. That's not going to opt them out of the collection of cookie data by third parties operating on the site. So there practically will be, unless you are one of these companies that's connected IP address to email address in a CRM, in which case you better be tying these opt-outs together. You're going to have to explain to people that there's two different opt-outs and that they've got to go through both process depending upon the type of data. Also, there's a lot of limitations to these cookie-based opt-outs. In fact, the primary way is to drop a new cookie. And so you need to explain, you got to do this on every browser and device. If you clear cookies, you're going to be clearing also your opt-out cookie. These are things that people don't necessarily think about that they should. Moving now into service provider contracts, I can tell you that the AG, when they're looking at whether or not processors are a sale or a service provider, have requested to see the actual contracts, even when there's thousands of them, as there are in most companies. And so a lot of our clients, took the position, we'll get to cleaning up these old vendor agreements. Right now, we're just going to have a good DPA that includes all the CCPA mandatory language for new contracts, and eventually we'll end up with it all done and not go back and hit things retrospectively. I don't think that's a safe position anymore. Also, there's a whole new set of contracting requirements that are going to be required under CPRA and the Virginia and the Colorado Act. I would say start implementing those in your DPAs now, because that's only 15 months away, and probably most of your service provider, vendor, processor agreements are going to last for more than 15 months. Back to you, Dave.
Actually, I'm going to pick it up here and talk about the next item that you want to address during your year-end review. Going back to my favorite solution, the data inventory, you need to make sure your data inventory is updated so that you can identify all of the places where you're collecting personal information. And then you want to make sure that you have a privacy notice, an appropriate privacy notice right at those different points, so that the consumer can have it, at or before that collection of data. And don't forget about your white labeled marketing sites, your login pages of portals, and your mobile apps, which I think often get forgotten. So that's another tool that really does help with the pre-collection notice requirement. And then also, as discussed previously, make sure you have a cookie banner on all your websites that allows for easy one-click opt-out of the sale of cookies. And make sure you're recognizing the global privacy controls. We talked about that earlier. It's quite clear that that needs to be considered. And also make sure that your cookie scans are happening on a regular basis. When we get engaged with clients, oftentimes they'll say, oh yeah, we have cookies and we kind of ran a scan, about a year and a half ago and everything's up and running. I mean, it needs to be run more often than that. Marketing teams are usually adding cookies, sometimes on a daily basis. So make sure you have a plan to continue to update those and bucket those cookies appropriately so that you don't have a situation with a sale of data. And then the last thing is you can consider an IAB framework, joining that or the DAA or some other framework to kind of also reduce your risk on the cookie front. Go to the next slide, Dave. All right, so now we're talking about planning for 2023, right? So this is where we're going to talk about CCPA going into CPRA, CDPA, CPA, the different states that have regulations that are going to go into effect January 1st of 2023. Very first thing on here is to do some preliminary scoping and information gathering. So if you happen to be a company that does not yet have a plan for your privacy program, this is where I would start. Even if you've already had to do some remediation activities, so you've already dealt with some cookies, for example, or you started your data inventory, it makes sense to take the time to go back to kind of assess where you are across all the requirements so you can have an overall plan. And so once you have that and everything's in one place, that's how you can prioritize. And you can work with outside counsel, you can work with a consulting firm like Ankara, but most of my clients can't just do everything all at one time. So they want guidance about what's the highest risk. Where should we start kind of remediating some of these gaps? So doing kind of an assessment at the beginning of a project is key for that. And one of the frameworks that we use and we recommend is the NIST privacy framework, which has 100 sub-controls that align to all the different requirements of the regulations. We've been able to map pretty much all of the emerging and active regulations to the NIST privacy framework. It's also been supported by the FTC, the IAPP, and ISO, the Organization for Standardization. And then lastly, the NIST and other similar privacy frameworks is potentially offering a safe harbor in certain states like Ohio, Connecticut, and Utah have some ability for safe harbor for organizations that voluntarily align to NIST or other frameworks. Back to you, Dave, I believe.
Yep. So number two there, number two and number three really are related. So updating the data inventory. There are some new definitions of personal information coming out in the new laws that we'll want to make sure we've identified and isolated in the data map. Records retention and data deletion are also going to be very important for organizations to have a handle on as we head into CPRA. There's risk in terms of the way the CPRA is written, in that we may need to disclose retention periods for different categories of PI in the external facing privacy notices. So, you know, a lot of us probably were involved in preparing privacy policies or privacy notices that go on websites, and the trend was to introduce a table which had the different categories of PI as defined by the CCPA, along with the purpose of processing, if there was a sale, if there was a transfer, and so on. We may end up having to add a column to that table that includes the retention period for each category of PI, and in fact, it could even be more granular than that, the way it's written. We hope to get some clarity on that point through the rulemaking process. But one thing organizations, and we're helping our clients do, is basically refresh the records retention schedules. And if you don't know this, OneTrust bought data guidance. Within the data guidance tool are records retention schedules. And so what we're doing, a lot of work now, is taking a client's existing records retention schedule, integrating it into the data inventory. So envision, as you're filling out the data inventory assessments, one of the questions would be, what's the record category associated with this processing activity or asset? And then tagging those record categories. Once those are tagged in the inventory, the exercise is really just exporting the inventory from OneTrust and doing some aggregation to rebuild the records retention schedule. Then what we'll do is we'll use the records retention schedules provided by OneTrust via data guidance as a QC mechanism to ensure that existing records retention schedules have the appropriate retention periods assigned to them, because the records retention schedules and data guidance have a nice link to the authoritative law that's driving the retention period. So for those of you who are thinking about how to solve for the records retention component of this, it's doable within OneTrust. There is a little bit of kind of workflow analysis that needs to be established to make it work right. I also know that they're in the process of rolling out a more robust and kind of automated solution to help with this. And then, you know, the other side of the coin with records retention is data deletion. That's really what we're talking about when we talk about records retention, is introducing a target operating model to delete data effectively past its use period. There are some new rights in CPRA. So it's important that the organizations take a look at those and then make sure that we're updating the privacy notices, that we're updating our consumer response workflows and forms so users can select, you know, what type of right that they're requesting. And Alan, I'll turn it over to you to kind of close us out here with 5 through 9.
Yeah, I mean, I think just we're sort of at time, so I think people want to read these. I would just sort of reinforce a couple things. One is Colleen's comment about, you know, doing a current state assessment and then a gap assessment for the new laws. so that you can remediate in Q4 and then build out a project plan to be 2023 ready. And then just a reminder to people, the employee and business to business exceptions from the majority of CCPA sunset at the end of 2022. And it's a hard sunset because that sunset is required by CPRA, which is not going to be easy to amend because it was a ballot initiative. So that's going to take a lot of work. And then Dave, what you mentioned, the retention limitations and schedule publication is going to be a big change for a lot of companies.
Yeah, absolutely. Well, great. Well, I know we're at the time, at the kind of 45 minutes or so, we're probably beyond it in terms of the length OneTrust had requested. So we'll look to wrap here. This is a pre-recorded session. We plan to be on the event in the chat box, responding to questions as this is played live. But I want to thank Alan for participating with us, and Colleen for your input as well, and Paul and Michelle for helping set this up for us. And we're looking forward to participating in a great Trust Week. Have a great weekend, everyone. Thanks again. Bye-bye.
Bye.